Attorney Stephanie Ritchie-Mize from the Montgomery County Bar, and I would like to reserve 5 minutes, please.
Okay.
I know your honors have read the brief. I would like to focus in on portion of issue 1, that being that the court erred in denying Mr. Lovelace's pretrial motion to suppress statements.
Yep.
We have abandoned the issue as to the interlocutory appeal. I think that the state was well taken on that.
I mean, we addressed that in Funk, right?
I'm sorry?
So we addressed that in State versus Funk, didn't we?
Yes, I think that was very clear, so we would go ahead and move away from that. I would like to focus on that suppression order denying. As the court is aware, it's looking at several different issues. We have, without question, a custodial interrogation. The court properly ruled he was in custody because when he came in at 8 p.m. that night, he was immediately cuffed to the floor. So the court determined you're in custody. So that part has already been decided. Now, the timeline is very important in this case because you have a defendant that comes in at 8:03 p.m., signs a Miranda waiver at 8:05. No issue with that original Miranda waiver. He's properly advised, he signs off. What you then have is a situation that starts rolling downhill quickly. The agents are in and out. They have fingerprinted him, done some other things, and the questioning starts at around 8:36. Now, for 4 straight hours, the defendant is questioned in and out with different officers. And it is at that point where we see voluntariness become an issue. We've set forth a number of factors in our brief that allow the court to specifically at the circumstances of the defendant. You can see from both briefs, and I don't think the state the state concedes. There's 6 times the defendant says he's cold. There are multiple times when he asked to go to the bathroom, and I think he has taken to the bathroom twice. But throughout this 4-hour period, we've got this constant dialogue where the defendant continuously states, "I'm cold." Now, the detectives testify, well, we didn't know it was cold. And of course, they're dressed properly. We have the defendant who's wearing a tank top and some jeans and is cuffed to the floor. So he does not simply say, "I'm cold." It's not an assertion he makes one time. It is over and over. I think the state concedes around 6 times during this 4-hour period.
But other than saying "I'm cold," I mean, honestly, is that enough? He doesn't say, I need a jacket, I can't,
He does
I'm not doing well, all he says, if you could ask my husband, I complain all the time, I'm cold.
But you're not cuffed to the floor at home, Judge.
Well, but being cuffed to the floor, I mean, how does that make you more or less cold? I mean, the officers, to that point as well, the officers testified, one said, "Yeah, I had on a long sleeve shirt, or something like that, but I'm cold nature, I always have one on," while Officer so-and-so was in short sleeves. So,
But I think he had a vest on.
well, but I mean, he didn't ask for extra clothing. He didn't say, "I can't think. I don't know what, I'm cold." I mean, to Judge Ayers' point, my wife's the same way. I'm cold. Okay, well, but that doesn't mean she can't think straight. It just means she's chilly right at that moment. So,
Judge, I think we have to look at how many times he says "I'm cold." If your wife told you she was cold 6 times in 4 hours, you'd probably do something. And the detectives knew.
I don't know. But, I get your point.
I should have never opened that door. Sorry.
I get your point. No.
I'm going to say we should hope.
But let's say this. But, okay, so, but really Judge Ayers' question is that enough? Because when we look at the totality of this, which is how we have to review it.
Yes.
The totality of this, he was taken to the restroom. It wasn't just a constant 4 hours just banging away at questions. There were breaks. I think he was, at least if I understood the record, I don't know that he ate anything, but he was at least offered food or drink at some point in time or never asked for it, one of the two.
I think he tells them, "I'm not going to ask you to order me
Yeah,
pizza."
there you go.
Because I think he knows that's not, had he not been cuffed to the floor, I think the voluntariness would shift a little bit.
Well,
He would feel
mean,
more free.
Ultimately, the question, right, ultimately the question is whether his will has been overcome, such that he otherwise would have remained silent or not confessed or given a confession.
Right.
But that the circumstances overcame his will, and that he found that to be the only way out, perhaps. So I think back to Judge Ayers' questions, if he's cold, but he's not complaining that people do something about it, if he says, I need to use the restroom, and that's accommodated, if he's not hungry or been denied food, if he's in a situation where he's being interrogated for a long time, but there are sufficient breaks in between, how is his will being overcome? So what about it in the circumstances of the interview show that he otherwise would have remained silent, that he otherwise would not have confessed, but for him being cold?
Well, I think in that situation, you have to look at the McKinney analysis and look at the totality
That's what
of
I'm trying to look at,
circumstances.
is that we're trying to see,
Right.
under the totality of the circumstances, how his will was overcome. So how was his will overcome?
We would argue, of course, that the prolonged nature of the arrest and interrogation, we know he comes in at 8 a.m., and we know that he is not finished until roughly 1:30 or 2 o'clock the next
We
day.
do, but we also have cases that uphold interrogations and statements coming from interrogations with longer times. And the time really only matters, I think, the time really only matters if it's affecting this particular defendant. So if you have me in an interrogation for 30 minutes, maybe I'm likely to confess. If you have someone else, maybe it takes a longer time. How is the 4 hours here indicative that it overcame his will?
I think we do have to look at him specifically. Another defendant may have said, oh, I don't like the temperature in here, and moved on. But what we see is this defendant constantly repeating he's cold. He's kind of obsessed with the notion that he is not comfortable. Then we have the agents making inducements. We're not going to charge anybody. Later, we're going to protect your family. Adding those types of inducements to an interrogation that has been going for about, I think, 17 hours. Certainly, I think in the broad context, looking at everything, he's not, he is 37, so he's not young like in McKinney, but he is certainly not sophisticated. We see on the interview that he's probably of average intelligence, but he's consumed with this issue of being cold. And so I would argue that simply because it does seem specifically to him to be such a distraction, that it should be considered as involuntary. Now, moving on, I'd like to move on to the next portion of the issue, which would be the invocation of right to counsel. We know around 1 p.m., he says, the exact words are set forth in my brief, but can I have an attorney?
And the court has held that that statement is not an invocation of right to counsel.
In the, and
the
I
Supreme,
did,
the Supreme Court has said
Yeah.
asking if I can have an attorney is not an invocation of the right to counsel.
when I looked at the cases set forth by the state, especially, I think it's the Brissot case where it is the can I language. You know, a lot of times you get, maybe I should, or what do you think, or these probing questions. And looking at the cases that are set forth in the state's brief, the Brissot case I think is very different. He uses the can I terminology, but it's can I in terms of we're standing by the side of the highway, can I have an attorney? In this case, we have a defendant who is chained in the room, who has obviously some uneasiness with the physical conditions, and he says, can I just have a lawyer with me? That way they can help me out on what I need to be doing. So it's not you think I should have one.
But that's what I'm saying. I mean, the court has said, whether it's can or whether it's any other probing question of the officers by the individual, if it's just a question of can I do this, should I have my attorney here, those kinds of things is not an invocation of the right to counsel. You have to make a clear and unequivocal invocation. I want my attorney. I'm not talking to you unless I have an attorney. I want to call my attorney, whatever. The open-ended questioning of, you think an attorney would help me here? I think maybe having an attorney would help me here. What do you think? That is not an invocation of the right to counsel. And so can you point to me in the record where he unequivocally invokes his right to counsel?
No, I think the "can I just have a lawyer" is the closest he comes, but if we consider that this defendant is aware of his legal rights, he's been arrested
Right,
before.
that's just it. He's aware of his legal rights because he was Mirandized, and they told him in that you have the right to counsel, and if you want questioning to stop at any point in time, all those things that are in there. All he does was ask another question, which he has already been told and acknowledged that he knows the answer to. And the court said that's not an invocation of the right to counsel.
Well, and I think, and it goes maybe even a step more deeply too. The whole purpose of having an unequivocal request is to distinguish someone who has made the decision to have a lawyer as opposed to someone who is still contemplating the decision-making process. And so in that context, sometimes we have statements that say, hey, can I have a lawyer? The state actually cited, I think, 2 cases, and you've distinguished arguably one of them. The other case it cites is the Nash case, where ain't it possible I could have a lawyer? That one actually strikes me as far more closer to this case and indicates a defendant who is still in the decision-making process, weighing the pros and cons about doing that. What about the statement here that shows that the defendant has made the decision for counsel and is not still weighing the costs and benefits of it?
I think we look at the time, how long has passed in the interrogation. If he were being Mirandized and said to the agent, "Can I have a lawyer?" as though he was unclear about his Miranda rights, that would definitely be more along those lines.
Sure, but the officers then stop, right, and then kind of probe on that a little bit, and then the defendant disclaims wanting a lawyer. So what are we supposed to make of that? All of that's in context seems to suggest to me that this particular defendant was still in the decision-making process, that had not reached the decision to have a lawyer, but was exploring it. So what's the best argument in response to that?
I think the best argument in response to that is the agent said, "That's up to you," and starts to pack up. And I think that's where the defendant thinks, okay, we're done here. I've invoked my right to counsel. He's going to pack up. We're going to separate and move on. And so I think they both knew it was invoking his right to
But I
counsel.
thought the defendant came back and then said, no, I don't want a lawyer.
No. So
What
they
does
leave.
he say? What does
Yeah.
he say?
So at roughly 1:08, they stop. 8 minutes after he says, "Can I just have a lawyer?" He said, "That's up to you. I only wanted the truth." Then they break. And there's like a 30-minute break wherein I believe the agent absolutely knew he wanted an attorney, so he didn't go back in there. There was brief contact around 1:40, and they leave him in there for several hours, and finally at 5:26, book him in the jail. Had to be transported and booked him in the jail. So the agent didn't continue to question him. He knew he had invoked his right to counsel. He said, "That's up to you," and he packed his stuff up and left. Then what we have is them coming back in there for a second interview at 11:35, knowing he has invoked his right to counsel. And this is the interview which we think, without question, should be suppressed. At 11:35, this defendant has been in custody about 15 hours. At 1 o'clock, he has said, "Can I just have my lawyer?" The agent said, "That's up to you," and leaves, indicating, for all intents and purposes, he understands he wants a lawyer. He would have continued to question him if not. And so we have them transporting him at 5:26. We don't really know what happens between 5 a.m. and 11 a.m. other than he's brought back for an additional interview. And at this point, this is where I believe the agent definitely makes a mistake. He said, "You remember you were Mirandized, all that junk." And I think the court has been clear that you can't call a Miranda waiver all that junk. I think I'm out of time.
You can finish your point.
So I believe the officer's comments, when he says all that junk, number one, that doesn't say anything about anything substantive about Miranda. And we've got a defendant who's been in custody 18 hours and has invoked your right to an attorney, which is why he said all that junk instead of "Do you still want your attorney?" Because that was a way to continue the interrogation of a gentleman that had been awake probably more than 24 hours at this point, had not been fed, may have gotten some water, used the restroom once we know of.
Thank you.
Thank you. Thank you.
morning, Your Honors. Liz Evan on behalf of the state. I would like to address, I'm going to go these in reverse order because I think that there's been a little bit of confusion about what exactly happened around the alleged request for counsel. So at 1:01 a.m., he says, "Can I just have my lawyer with me? That way they can help me out, maybe the expletive, what I need to be doing." Agent Adkins replies, "All right, that's up to you." There's a couple more statements back and forth, and then Judge Greenholz, you're correct. He says, "I said I didn't consult with my attorney because I felt like I didn't need to." So there was another 7 minutes
I thought that
before.
there was something else there. Yeah,
Correct,
okay,
Your Honor.
all right.
So there was a full 7 more minutes of discussion where, as Your Honors will see, I'm not sure if you've been able to access the video. I know you are having some difficulty with that. But when you watch the video, you will see what was leading up to that was he specifically said, "What can I do to clear my name?" And both Agent Adkins and Chief Gillespie respond to basically tell the truth. You need to tell the truth. We know you were there. We have video of that, so they knew he was there. And it's at that point he says, "Can I just have my lawyer with me?" And the question for this court is, was that an objectively reasonable interpretation for them to believe that he was saying, "Am I allowed to have my lawyer?" So Judge Dyer, you're exactly right. This was probing the parameters of Miranda. He answered him truthfully and said, "That's up to you." And when he was told that's up to you, he didn't press the issue. He just continued to go back and forth in him and haw. So then he says, "I said I didn't consult with my attorney because I felt like I didn't need to." Then they leave and discuss with General Bryson whether or not to charge. They go in and talk to the co-defendant Powell, and about an hour and 45 minutes later, then they come back in, tell him that there's been a charging decision. And it's at that point he says, "What can I do to fix it? How can I fix it?" And so again, they say, "You just need to tell the truth." Of course, that's going to have to go through the district attorney at this point, because we don't make these charging decisions, they do. And he again starts to, "Well, maybe I should tell you, maybe I can't." And so at that point, he starts to pack up. It's 2 hours later. So he realizes, or Adrian Atkins realizes, this guy isn't going to say anything. You know, either you have something to say or you don't. That's what they told him, and started to pack up and get ready to leave. And so, and that also goes into the voluntariness, Your Honors. The defendant makes much of him being cold in this situation, but again, as you watch the video, you'll see he was willing to talk the whole time. He never asked for the interview to stop. He never asked for any kind of blanket or jacket or anything like that. And the impetus for his statement to officers was not, "I'm cold, I'm tired, I'm hungry, I just want to get out of here." It was, "Oh my gosh, they're charging me with felony murder, I want to fix it."
So your friend on the other side says after they take him into custody, and he's transported to booking and then I guess kept in a detention facility of some sort. The officer comes back, and typically the cases suggest, if not require, they at least suggest that there be a re-administration of the Miranda rights. And I think your friend on the other side says there wasn't a re-administration here. What in fact there was a diminishment of those rights by saying, "You remember Miranda and all that junk that we read to you," as if to imply none of that's important here, you don't need to worry about that. Also, perhaps arguably, I don't think she went this far, but perhaps arguably not giving the dispelling effect that the Miranda waivers are intended to give. What's the state's best response to an inadequate re-administration of the rights?
Well, Your Honor, there wasn't, when I was reviewing the record, I didn't see there any kind of a break in custody.
Mm-hmm.
So I was not, I felt like if there was an actual invocation of the right at 1:01 a.m., then a re-administration was not going to cure that. And I thought that was what the argument was from the defendant, that that this was not going to be a curing effect. And I wasn't going to push back on that particular thing because we don't believe that the 101 was the invocation.
Sure, but let's assume there was no unequivocal invocation. I don't know that the cases go so far as to require a re-administration, but it's certainly suggested. And to the extent that there was an attempted re-administration here, but it was ineffective because it was diminishing, what effect should we give the re-administration here?
Well, Your Honor, I would say that if this court determines that was ineffective, that it would be harmless because he didn't say anything at 11:35 that he didn't say at at 3 o'clock in the morning.
Okay.
Not anything of substance. He was basically just reiterating, trying to point out where he might have thrown things, which of course were never recovered. So I would say that if that was error, then, which we don't believe it was, of course, but if
Sure.
that was error, then it would have been harmless because it wasn't anything.
This is why argument is so valuable for me sometimes, because I think I've misunderstood the record. Where is it that the contested statement appears in the course of the interrogation?
I'm sorry, what do you mean?
So counsel is objecting to admission of the statements of the accused. You know, he made a confession, said stuff he shouldn't have said. Where did that come in as far as the time frame here?
My understanding was it was anything that he said after the 3 o'clock in the morning, that he said, you know, that yes, I went down there with them and on. Anything after that point was my understanding of what they were challenging.
No, I think Judge Greenhold's question, because I'm
Okay.
a little confused. Okay, he's taken into custody at hour 1, okay, right?
Yes.
We have him here all during this time period. At some point in time, he confesses or gives,
At admission of some
he
sort.
gives admissions, you're right. And then at some point in time, if I'm not mistaken, he then also goes around town or whatever with them,
right.
showing, here's where I threw the gun, this, that, and the other. So there's two different, I'm gonna call them two different interrogations. One, the physical, where he makes admissions, and then the other, the tour around town, so to speak, where he makes admissions about, here's where this is, okay? Where does the oral admissions come into play as far as from when he's taken into custody until whatever it is, like 3 o'clock or the next morning when they go around town? Where's the oral admission come into play?
Are you asking where in the record it is?
Timeline?
Time-wise. Okay, so,
From hour 1 to hour 17.
Okay, so
where is it?
yes, Your Honor. So he was taken into custody at 8 p.m. in order to execute a search warrant on his DNA and fingerprints.
Right.
That took about 30 minutes. Then questioning began. It went on and off for a while. There were definitely periods of quiet, many, many minutes where they'd sit there and say nothing. So then the time when he actually starts to change his story is approximately 3 in the morning. So that would be, math is hard.
Where was the invocation,
Yeah.
the alleged invocation of the right to counsel?
At 1:01 a.m.
Okay, so
2 hours
hou-
before.
so he starts, as you say, with the admissions 2 hours after the alleged invocation of the right to counsel.
Right, Your Honor, but at the same time, there was about an hour and 45-minute break in
Right.
there. So even though it was 2 hours later, there was no one in the room with
right.
him except to take him to the bathroom.
Okay,
So then where does the re-administration of Miranda
Right.
take place?
That is, and it's on the body cam footage, so you'll all be able to see it. It happens the next morning out in the area.
So that's like at 8 o'clock or something, if I remember
Oh,
correctly.
it's even later than that, Your
Okay.
Honor. I think it's like 11 in the morning even.
Okay, right. So at 11 o'clock or so, sometime that next morning is when they go around town, and it's on the body camera, and
Right.
that's when we have the re-administration of the rights. So he's already made the admissions, the oral admissions.
Right.
And there's been a charging, and he's fully in custody at this point.
Has been the whole time. We did concede
Right,
that.
I know, but you know what I mean by that.
Yes.
Like, and so, and then we start at some point in time late, mid-morning, hey, we're gonna go around town, you're gonna show us where you threw the gun.
Oh, he offered to, yes, but yes.
But that is where the police officer says, hey, you've already been Mirandized, you know all that junk, or whatever the quote is.
Correct. Right.
Okay, is that,
It does, and so what you're saying, and you'll forgive me because I'm not completely familiar with the timeline. What you're saying is after what I'm calling the re-administration, he gives no statements during that time that he had not already given. There's no new
Nothing.
incriminating statement at all.
Nothing of substance, Your Honor.
All right.
Nothing of substance.
That's
No,
helpful,
because
Gerald.
again, if I understood the record, and I'm trying to help myself out as much as I am Judge Greenhold.
Thank you.
Yes.
I need it.
In the original admission, he says something about, that's where I disposed of the clip, is at
Yeah.
X location.
And
And then the
gun.
next morning, he takes them to X location and say, here's where I disposed of the clip. Is that, I know
Roughly.
there's more in there, but that's
Yes.
the general concept. This time is no different than this time.
I wouldn't say
second time-
no different, but substantively, Your Honor, I would say there isn't any substantive difference in his statements between those two times.
Yeah, that helps me. I hope it helps Judge Green.
It does. I appreciate that, I do, yeah.
So if there are no further questions on this, I would rely on my brief for the remaining issues.
Well, I want
Oh,
to,
okay.
I do want to kind of go back to the whole
The voluntary.
administration of Miranda. Were they required to re-advise him of Miranda later that mid-morning before they took him out to show where he disposed of the clip? Or does the original Miranda cover it all?
Well, Your Honor, because I did not believe that was the issue that was being raised, I did not brief that particular issue, but I don't believe that. My gut tells me, Your Honor, that that is not the case because there was no break in custody. But I would need to do some supplemental briefing for you.
So, under your theory, I want to make sure I understand when you say a break in custody, they bring him in that night, long conversations, blah, 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 blah. About 6 o'clock, I'm making up timelines here. 6 o'clock the next morning, they say, Mr. Jones, you can go home. If we need you, we'll come back and get you, or whatever the case may be. They go pick him up at 10 o'clock the next morning and say, we want to talk to you a little bit more. They have to Mirandize him at that point. And
Yes,
the
Your Honor.
break in custody is kind of
That's what I'm
very
referring to.
generic. Okay.
Yes.
And so the break in custody here, I mean, he's physically in custody, but he's not in the officer's presence the entire time. And so your position, and I don't know that I disagree with it, but I'll be curious to hear your friend's response. Your position is that it doesn't matter where the defendant is being held, and it doesn't matter with whom the defendant is being held, so long as he's in state custody the entire time.
For this particular offense,
Yeah,
I
that's
wouldn't.
right,
Right.
specific, okay.
Correct, Your Honor.
Okay.
He was transported to be booked and then brought back out.
All right.
So if there are no further questions, did you have one, Judge Ayers? I thought you were. I would ask the court to affirm.
Thank
Thank
you.
you.
I think you have a few moments left of your rebuttal.
Thank you. First wanted to answer the question regarding the Miranda waiver again during the second period of time. I would tell you the way you know it's important is because the agent brings it up. He knows he needs to do it, and that's why I said, do you remember that junk? So not only does he know he needs to do it, that's why he brings it up, but he then diminishes.
Well, actually, I think you can also interpret it as the officer may think it, doesn't mean he's required to do it.
Yeah, it may be a difference between best practices and what is required
Right.
by law.
I mean, if he's in custody 2 hours or 15 hours, and a different officer walks into the room, that officer's not required to Mirandize him, but he may say, hey, just out of best practices, you remember your Miranda rights, right? You and Officer X talked about them. He's never been out of custody, of the state's custody. It may be best practices, but it's not required, is it? It's not required for that second officer who's never spoken to him, whether it's 30 minutes later or 5 hours later. As long as he's been in custody the whole time, that officer's not required to Mirandize him again, is he?
Well, it's the same officer. So
That's not my hypothetical.
Yeah. If another officer came in,
Another officer, is he required?
I think if he is going to question him, that,
So
And I get the
every
best
officer that comes in
practices.
contact with him, as long as he's in custody, is required to Mirandize him?
only when they're going to interrogate him.
Every time they walk in and out of the room?
Only if they're going to interrogate him. So no. So if you're transporting or doing other things, no. But if you know you're coming in there to clear up some statements that he made earlier, which is exactly what his plan was, then you need to re-Mirandize.
Can you cite me a case that says that an officer who leaves a room for 5 minutes or 3 hours and comes back to ask a follow-up question has to re-Mirandize the same defendant?
I hesitate to say
I
a
mean,
case. I
but
just
Mosley will say that in the context of the right to remain silent, perhaps, because one of the facts that was important to the Supreme Court's decision in Mosley was the re-administration of the rights in that context. In this context, though, and I think this is where Judge Dyer is asking, in this context where there hasn't been an invocation of the right to remain silent, and at least maybe arguably there hasn't been an invocation of the right to counsel either, is a re-administration required? I'm not aware of a case that holds that. Are you aware of a case that holds that simply because there's a break in the interrogation without an invocation of rights, that re-administration is required?
I can't put all these facts into a case I can come up with off the top of my
That's fair.
head.
I can't either.
Yeah.
That's why I'm asking.
I mean,
Completely fair.
certainly what I would argue is he's not still sitting in that little room in the back with the same guys. He's been transported, he's gone to a
But like
completely
in
different
Mosley and in Crump, I think maybe in Crump, don't hold me to that, maybe Crump. I mean, there had been invocations of at least the right to remain silent there before readministration occurred. And here, maybe not, so I think I'd be curious if if you were aware of a case where readministration was required in the absence of an invocation of either of those rights.
I've certainly had cases where that ruling has occurred, but not at an appellate level or anything I could give the court.
And it may be too that if he had invoked his right to counsel, I guess my guess is you couldn't re-administer and ask anyway, right? I mean, once the
Well,
right to
I mean,
counsel.
definitely think he invoked his right to counsel. So as far as we're concerned, at 1 a.m., everyone agrees he's
Arguably.
invoked his right to counsel because the agent says, okay, if that's what you want. And then there's some more questioning, and the state is correct. There is some more questioning. I'm not convinced that that's the most incriminating stuff, because when he comes back in there at 11:30 or goes and gets him at the jail where he's been transported, because he has left one area and gone back to an entire, I think he went to a different county. I think he starts in Montgomery County and he ends up in Stewart County Jail. So at 11:36, they come in there, wake him up or whatever. I'm not sure if he was sleeping, but he's been there since 5. He says, you know your rights, all that kind of junk, which I think indicates he knows he needs to re-Mirandize him or he wouldn't have said it. He diminishes that right, and then here's the problem. He proceeds to ask Lovelace to explain statements he made at 3 a.m. Now, you can either, number one, agree that he invoked his right to counsel at 1, so 3 o'clock is completely off the table, or 2, you can say, okay, those statements were okay, but you didn't re-Mirandize him as you should have, so anything clarifying that first statement should be admissible also. So there's kind of there's several things going on at one time. And if your honors don't have any more questions, I'll rest.
Thank you, counsel.
Thank you.
I think that concludes our morning docket.
Does.
All right, we will stand in recess until after lunch.
All rise.